G'day friends and foes, my name's Arjay Martin and this is the TINLA, or This Is Not Legal Advice, episode number 9. This is a short follow-up to episode 1 where I discuss why, or one of the main reasons why the so-called royal style and title of Queen of Australia is legal and void, and therefore, it's void ab initio, void from the beginning, has no legal effect. And anyway, I did say that I would do a follow-up video and discuss things like the lack of head of power, which I'll get into in a second. Also, I will read the comments from TINLA 1 left on YouTube, and also someone was kind enough to send me some more information via email but wished not to be identified. So I will read a little bit of information from that doesn't identify the person and not of personal nature, that kind of thing. And I'm trying to keep this video very short. I appreciate that a lot of people don't like watching hour-long videos despite the important contents. And as I keep telling people with the TINLA videos, if it's about an hour long, I try to do it so it's about 20 minutes of substantive content and then about 40 minutes of referrals, references, whatever you want to call it, so that anyone, even a High Court judges can watch these videos and can follow it and see that it is correct in what I'm stating, that kind of thing. So as a lot of you would appreciate, there are people, including some lawyers, who they basically make very material and significant claims and don't back it up with any information. So they shouldn't really be doing that, but it just makes it a lot longer and harder for people to find the information to try and verify it. So, they might say, according to XYZ, you can't have a blue flag flying in Australia, as an example. Yet then they don't show any references to that, so that makes things difficult. And anyway, so I will get on to reading the comments. I'll do the head of power thing first. So let's start with the federal government has, the federal constitution, the Commonwealth of Australia Constitution Act, 1900, UK or imperial, and all of its power must derive from the law. It's called enumerated powers, or it has to be listed, the powers, in order for them to form valid legislation, whereas the states have so-called plenary powers, which is a general power to make law, even though, maybe if you really get into that, that is not entirely correct, in that perhaps the states really only have enumerated powers from when they were colonies, whatever was left to them as reserve powers, and then also, of course, the concurrent powers, or powers that the federal and state governments can make laws with regard to those heads of power. And anyway, so there's a thing called constitutional method. Within that, there is the characterization test, and there's different versions. There's like a 3-step version, 5-step version. They basically say the same thing. So in order to determine if a federal or Commonwealth law is valid, using the 3-step method, first we must look at the direct legal effect of that legal change, and we can skip over some of the details. Step 2 is to look at if the power, or if the Parliament has the power with respect to a head of power, and therefore, if they've got a head of power defence, then if a law is related to defence, and then defence is a bit more complicated because there's 4 different stages of, I guess I should say, war or whatever in Australia, but I'll skip that. But the 3rd step is to look for any constitutional prohibitions. So TINLA 1 discussed a constitutional prohibition using the Statute of Westminster Act 1931, which was adopted in Australia in 1942 with the Statute of Westminster Adoption Act, and backdated, or purported to be backdated, to the 3rd of September 1939, which was the start of World War II. So that act actually specifically prohibits the changes that were made, and there's also certain processes that need to be followed in order to change a royal style and title. That again is covered in TINLA 1. And anyway, also with the 5-step process, one of the steps is that the correct procedures are followed, and then it divides the prohibitions into express prohibition and implied prohibition for that law. So anyway, basically within the Constitution there's no power or head of power that the government can use to change the title of Queen of Australia, or the proper title to that title, royal style and title. And it'd be fun having people trying to guess which power such a change is with respect to. I don't think they can, because I think there is no power to support it. Even something like the external affairs power, because part of the argument someone could try and use, which is a faulty argument anyway, is that the UK is a foreign power, therefore us changing the Queen's title is to do with external affairs, and that is, not correct in law. And anyway, so if you go on to Google and look up something like constitutional method, the characterization test, or you can look in certain cases such as re Dingen, ex parte Wagner from 1995, High Court of Australia, case 16, then you can see the case law on such matters. There's also the Tasmanian Dams case, etc., but they were earlier authorities. Anyway, so now I'll read through comments that were left. So I should probably start at the bottom, because that would be the first comment. So, okay, maybe it's not the first comment. So Grant McDougall, CPO, said, and I will censor what he said because he's swearing at me, and I do appreciate that later on he appears to have changed his stance on the VONC voting process, of so-called vote of no confidence, which he was told many times by myself that VONC voting was a load of garbage, that there was no power to go through the method that they claim, and that would be effective, and I'll cover that in another video. But basically, VONC voting is where there is a claim by a Liberal parliamentarian, and he claimed, and many people have claimed since, and got quite popular on YouTube about, most notably Karen Brewer, and then also Grant McDougall, that if you put a single line, and it has to be a single line for some reason, through each candidate's name, then write no suitable candidate to follow my will, that if the majority of people did that in an electorate, that election would fail, and all of those candidates would never be able to be elected or run for parliament ever again. So, and then, the simple question is, what law says that? And then you get abuse. But anyway, Grant later seems to have redeemed himself somewhat. He made a video telling people that he thinks it's a good idea to vote for the Great Australian Party. But anyway, so this is before that. So, hey, Sockhead, I'll say Sockhead instead of what it is. You make a post on a video on sacking the Parliament of Australia as fake. Well, sockhead, it's not fake, as what information you talk about backs what is explained in the video you commented on as fake. So I replied, yes it is, as in yes it's fake. I already provided you with such information last year, so you blocked me. Then he said, yeah, I did. Why, you're a sockhead. So I replied, what a rude person you are, Grant. So did you realise that you were wrong with vonk voting, which I ended up writing 4 months after that other reply. So it must have been, just before or just after he made the video to say, vote for the Great Australian Party. Anyway, Ms. Puddle Ducky wrote, I hope at some stage you will talk about the unconstitutional Phelps Medivac bill. How can lefty doctors who assess refugees' health stop our government's final say on determining who can come into Australia? And how can the bill be constitutional when the government only has 72 hours to determine the character and source criminal records of an undocumented illegal? It does say of twice, but typo. So in other words, if in the bill apparently it had a 72-hour window to determine the character and source criminal records of the people with the Medivac bill. So I just replied, I can cover many topics if people support me. So I don't just talk out of my hat, so to speak, and things require research, but that's what I replied. Tovarich Ryan wrote, I'd suggest having a look at the coronation of HMQE2, so Her Majesty Queen Elizabeth II, and what crown she took. You will find it was the St. Edward's crown, in brackets Catholic, and that does not have line of authority to the imperial realm, in brackets Christian, where most of your evidence resides, 1953, ... So that is going on about Stephen Spires, or Stephen Spears, depending how you want to pronounce his name. His information, I will do another video on the St. Edward's crown. And anyway, so I replied, cheers Ryan. St. Edward, this covers it anyway somewhat. So cheers Ryan. St. Edward is a saint of both the Catholic Church and the Church of England. Westminster Abbey was built by the King, indirectly, i.e. he ordered it to be built, as a Catholic church since Anglicanism didn't exist for some 560 years. It is an Anglican church since Henry VIII, Catholic again under Mary I, Anglican again under Elizabeth, that's the first. It has been under direct control of the monarch since 1540. The monarch is a head of the Church of England, in brackets Anglican. It's also Presbyterian in Scotland, Church of Ireland, whatever. But anyway, since Scotland merged with England, insert Church of Scotland / Presbyterians, not as head of the church as they say God is, but second in charge, the supreme governess and defender of the faith. I can make a video on that. A summary is that it doesn't matter which crown she chooses to wear, imperial crown versus St. Edward's crown, out of her 6 or so that she owns, or her tiaras, etc. So there's about 6 crowns. Again, I'll do a proper video and show pictures of them and make sure there's 6. But she can wear what crown she likes. She's the queen. And anyway, some might get peeved if she went out in public with the Indian imperial crown. I suppose she could argue, but the emeralds really set off my eyes. Yet ultimately she is the crown. I'm sure that you've read Stephen Spires' works, and that is where you are getting it from, the information, and that such an answer might well give you cognitive dissonance, but truth matters more than offending people or whatever. And thank you for your suggestion and comment. So he replied, I assume Tovarich is a man's name. It would seem you haven't gotten around the significance of the official King James Bible 1611 and its use in coronations like that of HMQV, Her Majesty Queen Victoria, and King George V. Heraldic symbols mean so much more than a pretty crown. Cognitive dissonance, really. So I replied, not being funny, Steve sends his minions to debate me, who then tag each other to tell me about the crowns and flags. Would you rather me have told you what you wanted to hear to support your views taught by Steve, or accurately? Surely the latter disappoints many people at first until they realise one day being should be that it's the truth. Typo, whatever. And feel free to disagree and educate me, little smiley face. So he replied, I don't know who you think I am, but I'm glad you've addressed line of authority. Cheers, bud. By the way, I have not suggested HMQE2 is Queen of Australia. She is an administrator without power because, like you pointed out, they had to create Royal Powers Act just to let her have something. So I replied, Royal Powers Act equals shows she has power. So that's an act basically that says that, you know, when she's in Australia, she can exercise her powers, even though really it is unnecessary to have such an act. But anyway, and then there must have been other people's comments that Facebook's deleted or something, or they've deleted it themselves, because I've got hashtag Neville-M Layden, so little tag to that person. So I wrote to Neville, vested in what? Question mark. Where are your references for making such claims? Are you another Stephen Spires minion? And then rebut this. Other royal assets that the Queen enjoys but are owned by Britain include the Royal Art Collection, the Crown Jewels, $11 billion worth of UK property held through the Crown Estate, even unmarked swans on stretches of the Thames, to which the Crown has claimed ownership since the 12th century when swan meat was considered a delicacy. They are no longer eaten. And that was a little quote, or yeah, so that whole thing was a quote apparently from a Forbes article. So if you look up Forbes.com and then type in Queen Elizabeth lives like a billionaire but is herself not quite as rich. So I guess I can post that link as well for this video. And then someone must have asked something about having a chat window, so I wrote, there are currently not enough subscribers to my channel, that is, so that YouTube would let me have a chat window. And then Peter Cross wrote, great work, RJ, many thanks from all those seeking the truth. So I wrote, thank you kindly, Peter, smile. Nina Hadges wrote, thank you for sharing information with us. It is important to bring the truth to light. So I wrote, I am trying my best, thank you, smile. Craig Foote wrote, hi RJ, good work. You are on the right path but have missed some important points. The New Zealand Parliament has responded on the basis of my request for this information. I did a Freedom of Information request around June 2016 and received a response from the Executive Council of the New Zealand Parliament in which they state, quote, there is no evidence of any consent to the Royal Style and Title Act 1973, unquote, or finish quote. Supporting your position, but with evidence which can be used in matters from a Dominion Parliament. Requests were also sent to South Africa and Canada, but no response was received. They do not need to pass acts assenting to or not assenting to these administrative processes. They are often handled diplomatically, for example at CHOGM, the Commonwealth Heads of Government meetings. There are also 4 Freedom of Information responses from the Australian Department of Prime Minister and Cabinet, which state that there was no head of power to create Royal Styles and Titles Act 1973. There is another Freedom of Information response also from the Department of MP and Cabinet, stating that the then government had no power to create corporations except for banking and financial institutions per Commonwealth Constitution, which is important as the Queen of Australia is a corporation sole. Further evidence is on page 163 of the Australian Government Style Manual, which states monarchs are enumerated with Roman numerals. The Queen of Australia is called Elizabeth II, not Elizabeth II, as in Roman numerals, as per a de jure monarch. There is also evidence of both monarchs assenting to legislation on the same page of the Victorian Government Gazette, page 3888 of the 26th of November 1973, proving the existence of the 2 separate monarchs, showing one has Roman numerals and the other does not. The fact that the New Zealand and Australian governments responded to the 2013 request re-succession of the eldest child to the throne, whether they be male or female, and allowing Catholics or those married to Catholics to be made king/queen or something similar, shows that they are applying the requirements of the 1953 RST, Royal Styles and Titles Act, and or the Statute of Westminster Acts to assent as set out in your video. How can I get these documents to you without revealing your/my email address on this public page? Okay, so they just didn't want their email address revealed. So that's kind of helpful, because otherwise, it makes it hard to read someone's comments that's not publicly available and then with the information that that person has kindly provided. So luckily it's only not revealing their email address. So I replied, Mr. Foote, and then I quoted his part about they do not need to pass acts assenting to or not assenting to these administrative processes. They are often handled diplomatically, for example at CHOGM, Commonwealth Heads of Government meetings. So that was the quote. So I wrote, I disagree with that part of your comment. The requirement is for the Parliament of all the Dominions plus the UK, then later all of the Commonwealth governments, remembering that the Statute of Westminster Act is constitutional law and Royal Style and Titles Act are subsidiary legislation. Therefore, the subsidiary legislation could only strengthen, not lessen the requirements. Also, the Royal Style and Titles Act must be read together with the Statute of Westminster, but not the other way around, depending on the topic. Your other points are very interesting, potentially very powerful though. There is a lot more to this video that meets the eye, and also I'm intending on having follow-up videos to each of the TINLA videos later, or if only a quick one, then just attached to the next episode of TINLA, also depending on video length, etc. You can email me at vote.a.martin@gmail.com. Thank you kindly. And then about a month later, apparently I wrote, hello, Craig, did you send that email? Losing my voice a bit, but such is life. So Helena Smirnis wrote, thank you, love the detail and references. This is very important and much needed information that the masses would do well to know and understand. Would be great if you could go over the Local Government Act 1989, especially with the Victorian new Local Government Act 2018 wanting to be brought in, which would be disastrous. So I replied, thank you, Helena. Each of these videos takes many weeks of research to find the information, which I do have many pre-planned / research. As I really started about 1.5 years ago, so I might be able to put out one a fortnight. So the video just cut out there because I ran out of room on my hard drive. But anyway, so I was reading Helena Smirnis's comment, and I was reading my reply to that actually when it cut out. So continuing from that's why. So that's why I'm not being funny in saying that I can only do them if I'm well supported. YouTube even changed the monetization rules last year so that 1,000 subscribers and 4,000 hours of one's videos have to be watched in the previous 12 months to even show an ad for a cent or two per view. Yet another benefit to the viewer is that this is original content, brand new knowledge creation. For this type of video, trawling through statute after statute and case after case, there's little point making videos with unsubstantiated claims, even if those claims are genuine, like such and such is illegal, and leaving off how or why. The content is prophetic and game-changing, although because it is the law that... It's annoying having the light shine in my eye, but anyway. So the content is prophetic and game-changing, although because it is a law, then it is difficult to make the videos more interesting without making the videos not being taken seriously. It is more game-changing than I can point out, as otherwise there would be great resistance from those that will disbenefit, rather than getting the legal fraternity to go through and admit the correctness of my claims, and moving on from there to the next piece of the puzzle. I guess I should post this in main thread too, so I ended up doing that. And then I also said thank you to the new and existing subscribers / likers / sharers and viewers, smiley face. Now, with information that was provided to me, there includes, let's go to the next page, a Executive Council Chambers of New Zealand, a official information request, information about the royal style and titles, and it's got a reference number, etc. So what the person asked for was documents to prove or provide for the assent of the Parliament of New Zealand to the Royal Style and Titles Act 1973 of the Dominion of Australia for the alteration in the law touching the Queen's title, consistent with the Statute of Westminster 1931, an act adopted by New Zealand. In the circumstances that the answer to the first question is not found or not considered as a requirement, I provide the following or further following request. I request the document / documents that provides for the reason why the assent of the Parliament of New Zealand to the Royal Style and Titles Act 1973 of the Dominion of Australia has not been given. So obviously Mr. Foote, or Craig Foote, knew about the Statute of Westminster Act requirements some years ago, because he sent this on the 1st of, the 21st of July 2016 was his letter to the Office of the Attorney General of New Zealand. So anyway, then the Freedom of Information request goes on that the Executive Council Chambers / Attorney General of New Zealand could not find any evidence that the New Zealand Parliament consented to the Royal Style and Titles Act 1973 of Australia, and you know, that's the most substantive part of that. It's got some extra paragraphs that go on, but you know, that's the important part. Also, There's the Australian Government Style Manual, which I did reply about that. Where's this thread? So there's a long thread of information back and forth as well, but basically I cited a UK court case which is about the so-called mailbox war that they had years ago, and anyway, within that there was an argument that I should just skip over that part, I guess. You can look up the case if you really want, but I describe it here, so found it. So this is from Wikipedia or something, or must use the information from Wikipedia, how it's set out. So note that whilst there is a distinction between a monarch's two capacities, official and private, there is an exception to this rule where there is unity of capacities, this being the style and form of address of the monarch. As described in McCormack against the Lord Advocate, among the royal prerogatives is the right and authority of the monarch to style themselves and command others to style them, or to so style them, with such combination of name and regnal number as they wish. Thus Albert, Duke of York, designated himself George VI on his accession to the throne. Accompanying this style is a form of address of the monarch. This varies across Commonwealth realms. And it says, they're always Your Majesty, and then about royal prerogative, letters patent, blah, blah, blah. But that also, again, isn't stating what happened past that or subsequent to that, which was the Statute of Westminster Act. And I'll just check the year for that case, because it's probably in the 1950s actually, and the Statute of Westminster Act should have already been passed, but it's ignoring that part that by statute they changed it that the Queen couldn't, just change a title basically. So McCormack against the Lord Advocate was from 1953, and there's a Scottish legal action, and basically it showed that Queen Elizabeth II was entitled to use the numeral 2, or the second, in her title in use in Scotland, there having never been an earlier Elizabeth reigning in Scotland. So what the case was about was there was no Queen Elizabeth of Scotland, therefore someone tried saying that the Queen couldn't use the title Queen Elizabeth II for Scotland because, there was no number 1. But then the court said, well, too bad, she can do what she likes, pretty much. Again, I don't think it would have covered in that case at all. And they don't have an easy link to it, about the Statute of Westminster Act. And of course it was a new Queen anyway, so they had to give her some kind of title. Anyway, so there's that bit. There's a lot of other good information within the email threads, but I can't cover everything. So then there's a Freedom of Information request to Department of Prime Minister and Cabinet, and this is actually by Neil Pickening. I forget how to pronounce his surname, but anyway, so he was after a head of power to support the Royal Styles and Titles Act 1973, and anyway, basically the Department of Prime Minister and Cabinet couldn't come up with anything, and basically wrote, we tried searching for things and we couldn't find any. So they claim there's no document to support or state about a supported head of power with the ability to change the title of the Queen. So this goes on for many pages. And they're the main ones, I guess. Apparently, I'm asked to look up the definition of person in a certain act, but I'm going to cover that act anyway later, at least part of it. As it say, person. But anyway, so that'll do, because otherwise the video is too long and boring and whatever, and I haven't prepared for this video so much as other ones, so it's got a little bit of time where I'm not actually speaking, that kind of thing, but hopefully you'll get over it, and the information's more important than the style of the presentation. So basically a summary is that there's no head of power that the government can use to create the so-called title Queen of Australia. Therefore, that's an invalidity of the legislation anyway, but then also it's specifically prohibited by the Statute of Westminster Act and Adoption Act. And I also did see on someone's website, where I assume it was in response to my video, there's a former police prosecutor, forget the person's name, it's not so important at the moment, maybe I can quickly find it actually. So what's it called? I think the website's called the Free Man Delusion or something like that. So someone told me that the person was a former police prosecutor, so I assume that that is correct, although maybe it's not. So this is a Free Man Delusion, and the person's name is Rob Suddy, however you pronounce that, and he apparently closed up shop in June 2019, saying, as I have recently left social media, my Facebook page, Freeman Delusion, is now inactive, and all inquiries should now be directed to this website. So they shut down their Facebook page, apparently, after the election. I need a better light than this thing shining in my eye. But anyway, so contents of the Freeman Delusion, the Australian pseudo-legal encyclopedia. And, maybe some of the information in the person's so-called encyclopedia is accurate and others not. So I'm trying to find this Queen of Australia. Queen. Here you go. So chapter 4. So section 3, constitutional misconceptions, supposedly. Well, it's interesting. They got what is the crown, which I'm going to do a video on what the crown is, and that'll be interesting to look at that person's claims. So royal style and titles. So, defender of faith, feudal conferences, So basically, I have read this before, but I'm not going to read the whole thing. But it's got the OPCA movement, which is OPCA. I don't think it's movement. Organised pseudo-legal commercial arguments. But anyway, so this Rob Sudi, however you pronounce his name, basically claims in relation to the Statute of Westminster Act, and again this is sort of going from memory and just quickly scrolling through, that so he basically claims that the requirements of the Statute of Westminster Act were met by some imperial conferences. So the Imperial Conference 1926 proposed a change to the royal style and titles designation for King George V. That change was incorporated in the Statute of Westminster 1931. In the second paragraph of the Statute of Westminster Adoption Act 1942, it states that in accord with the established constitutional position of all of the members of the Commonwealth in relation to one another, that any alteration in the law touching the succession to the throne or the royal style and titles shall hereafter require the assent as well of the parliaments of all of the dominions as of the Parliament of the United Kingdom. He then claims, and note that it's a parliament, it's not, just some random person signing a piece of paper, which is what Rob apparently fails to understand. And I did contact Rob via his website maybe 2 months ago, 3 months ago, something like that, or a month ago, whenever it was that I found this, and asked if he would like to have some kind of interview or debate or something, and as far as I can tell, I haven't been responded to. So I didn't see any emails, that kind of thing. So anyway, Rob goes on, at the Imperial Conference of 1949, it was agreed that it would not be necessary for each country to approve all the local variations of the title, unquote. And further in 1952, it was again agreed that each country should adopt a form of royal title suitable to its own circumstances, but retain a substantial element which is common to all. So again, it requires the parliaments of all of the dominions and the Parliament of the United Kingdom, not an imperial conference. But anyway, so then he waffles on and has got an extract from the Royal Titles Act 1953 UK. And then dominions. Then he's got a little extract part. The assent of the Parliament is normally given by legislation rather than a resolution. This is because the Parliament is defined in Section 1 of the Commonwealth Constitution as two houses and the Queen. A resolution may be passed by each house, but only legislation is passed by both houses and given assent by the third part of the Parliament, being the Queen, from the chameleon crown by Anne Toomey, who is an Australian constitutional lawyer. And then Rob goes on claiming that Elizabeth II agreed in meetings in April 1973 that Defender of the Faith be dropped from her title, but insisted by grace of God remain. She also personally assented to and made the proclamation regarding the legislation while in Australia on the 19th of October 1973, has some kind of scanned copy of something. And anyway, that's false information that Rob has there, because he's claiming that the provisions of the Statute of Westminster Act were fully complied with, because otherwise it would be invalid, and that's simply not the case. So Rob loses a point, I win a point. Anyway, also he's got what is the Crown. This will be interesting to read, because the Crown actually has a very specific meaning, which I'm going to put in a video one day. And you know, there's a lot of people that are incorrect as to what it means, and I can prove what it means. And anyway, so that'll do me. Hopefully the video is not 50 hours long. Apparently it must be about, I think the first video was 25 minutes before it cut out, and this is about 21 minutes. So anyway, please like, share, subscribe, you know, donate some money to me if you really want, or to a legal campaign, including to challenge the validity of the title Queen of Australia. And also one other interesting thing is that a High Court Justice, former one, did basically state that they were going to watch my TINLA 1 video, and then they didn't get back to me afterwards with their thoughts on it. So that's interesting. So perhaps it is that they realise that, you know, the title is invalid and that there's certain consequences from that, and that they didn't want to touch that with a 50-foot pole, so to speak. But anyway, so have a nice day. See you later. Sayonara. Good night. Whatever. Bye.